Trade deals are almost impossibly complex, especially when it comes to the fine print. And for many people, the Investor-State Dispute Settlement Mechanism, or ISDS, would probably count as such. But with talk of NAFTA renegotiations gaining steam, ISDS has become a hot topic. Roughly speaking, it allows companies to sue democratically elected governments for making policy those companies say loses them money. David Schneiderman is a professor of constitutional law at the University of Toronto's Faculty of Law, and he joins us now to explain. Good to see you again.
Thank you, Steve.
Thanks for coming in. All right, let's just handy-dandy explanation to get us started here. ISDS, I gave a bit of an explanation there, but embellish a bit more if you would. What is it?
Well, it entitles foreign investors, in the case of NAFTA, the North American Free Trade Agreement, Mexican and typically American investors, to sue the Canadian government should the Canadian government make policy changes that are adverse to their investment, so they lose some money, and runs afoul of certain treaty protections against, for instance, discrimination or expropriation or denial of fair and equitable treatment. So there are standards in these investment treaties that entitle investors to sue for policy changes.
Give me one example out of the headlines that we might be aware of.
Sure. Well, recently, the Ontario government entitled investors and Canadian nationals to apply for wind farm licenses. The Ontario government changed its mind. And so a foreign investor, in this case an American, was entitled to sue because the Ontario government changed its mind. And the way it changed its mind, according to the arbitration tribunal, ran afoul of NAFTA.
And Ontario lost that case, didn't
That's
it?
correct.
Okay, we'll figure out remedies in a second, but I guess why should, we see these things, sort of batted around all the time since NAFTA came in, and I guess I'm wondering why Mr. and Mrs. Everyday Ontario, in your view, ought to worry about this.
Well, there are all kinds of policy changes that can run afoul of NAFTA and these investment treaties. The thing that got me interested in it in 1994 was that the Canadian government was proposing implementing plain packaging of cigarettes. And American tobacco companies threatened to sue for hundreds of millions of dollars under NAFTA. This shocked me as a constitutional lawyer because we don't have such kinds of property rights in our Constitution. The Canadian government abandoned the proposal. Plain packaging turns out to have been a contentious issue. It was carved out of the Trans-Pacific Partnership Agreement, recently scuttled by the Trump administration. But it signals that all variety of policies, whether they be in regard to health, the environment, social policy, labor policy, everything is up for grabs under NAFTA if an investor can shoehorn it into one of those standards of protection, and it's not difficult to do in the usual case.
Now, I know we in Canada think we're purer than the driven snow, and it's the evil Americans who always run afoul of this thing. But, and Sheldon, if you would, let's bring up this graphic, which suggests that it's not necessarily the case. 70% of all NAFTA claims since 2005 have been targeted against us. There's Canada at the top there with 39 cases against us, and $200 million plus Canadian dollars have been paid out or are to be paid out as a result of those cases. 21 by the Americans and no money paid out. And there's Mexico at the bottom there, 23 with 200 million plus US dollars to be paid out. Why are we the target of so many of these disputes when we are, of course, purer than the driven snow?
Well, of course, we have a lot of American multinationals investing in Canada. And if Canada changes its policy and it's adverse to these American investors, they can sue. And Canada's often been on the hook for things that don't seem that serious, but nevertheless, investment arbitration tribunals warrant an award of damages. It's interesting, of course, that the Americans haven't lost a case, and that sends a signal about what arbitrators are thinking.
Why is that? How is that possible they've never lost a case?
Well, some of the claims were bad. Some of the claims against Canada don't win because they're bad, but there are some good ones that should have won.
So the system's rigged, as Donald Trump would say.
Well, you might put it that way. You might put it another way, and that is that arbitrators, this is a system of private dispute resolution, so everybody in the room is paid. These are lawyers and arbitrators who litigate these cases and decide them. They are worried about an American backlash. If the United States were to lose a case, they worry about a congressional and now executive response, and that is it might put an end to this investment treaty regime. We know this because one arbitrator said as much. he sort of pulled back the curtain on these proceedings. Late Judge Abner Mikva, who was a federal court judge, sat on one of these tribunals, and he said, you know what, the State Department spoke to me before the proceedings began, and so didn't run afoul of the procedural rules, and told me that if the United States loses the case, we might lose NAFTA. They said to Mikva, meaning not only NAFTA, but all these other investment and trade agreements that were being negotiated.
So that would put a chill on anybody getting too fresh with the U.S., I guess.
Precisely. And unsurprisingly, the arbitrators in that case decided in favor of the United States and did contortions in order to do so.
Now, $215 million in penalties against Canada sounds like a heck of a lot of money. In the grand scheme of international trade, is it?
Well, the people at Global Affairs Canada say it's not very much. It's a small penalty to pay to protect Canadian investors overseas.
Are they right about that?
Well, it's a question of how well these agreements benefit Canadian investors. In fact, a study by the Canadian Centre for Policy Alternatives suggests that many of the investors with Canadian registered addresses aren't actually Canadian companies. And Canadian investors themselves might win some of the cases and might lose more of them than they win, as is typically the case in these kinds of arbitrations. So it's questionable whether they benefit foreign investors. And I think what we need, or Canadian investors, what we really should be thinking about, it seems to me, are the benefits that accrue to host states, to developing countries who are desperate for new inward investment and sign these treaties in order to attract that investment. And it seems to me that the evidence is not very convincing that they have the effect of attracting new inward investment. So we're punishing states from taking measures that we were free to take up until the 1990s, for taking measures, for instance, to prefer local employees or services, or have a change of mind about a policy direction. We're punishing them for taking these kinds of measures that we in the developed world were free to do.
This all seems rather ironic, though, because as you suggested earlier, we're kind of tiptoeing around to make sure the Americans don't get mad at us. And that's why the Americans have never lost a case. And yet here comes Donald Trump saying, this thing is terrible, we've got to renegotiate it because we're getting killed. Who's right here?
Well, Donald Trump is upset about the trade rules. It's not clear that he actually understands investor-state dispute. I've hypothesized that if he did know something about it, he would want it. And that is, it has the potential benefit of protecting Trump properties overseas. Should a government, for instance, want to respond to some Trump measure, they could target Trump properties overseas, or American properties overseas. And ISDS provides an avenue for American investors, including the Trump Organization, to seek a remedy. His Secretary of State, Rex Tillerson, ran ExxonMobil, who've had some success suing states using ISDS. Recently, the province of Newfoundland, who was asking companies who exploited resource offshore of Newfoundland to contribute to a research and development fund. And Exxon sued Canada for Newfoundland's regulation requiring that a small portion of money be contributed to R&D development, and they won.
And they won. Okay, let's, at the risk of getting into the weeds here, I do want to get a better sense of how these things happen. When there is a dispute, and it has to go to this independent panel to consider, I guess a bunch of questions here. Who's on the panel?
The panel is made up of investment lawyers who sometimes are just full-time arbitrators.
An equal number from both countries?
Well, the claimant gets to appoint one. It's like labor arbitration. The claimant gets to appoint one, the respondent state gets to appoint one. Between the two of them, they're supposed to settle on the presiding chair or president of the tribunal. If they don't, then the facility that is hosting this tribunal, that provides the room, the chairs, and a secretary, might have the authority to then appoint one if they can't agree. So then you get the presiding chair really being the impartial a determining factor in the outcome of the dispute.
And does it go back and forth? In other words, on this case, you can have a Canadian chair. On the next case, you have to have an American chair, that kind of thing?
Well, no, it doesn't actually go that way. Typically, there's a small number of people who are doing this work, who are leading arbitrators in the world. Let's say top 10. And those are the people that keep on filling those chairs.
And again, the assumption will be that the Canadian arbitrators may have a bit of a soft spot for Canada. The American ones may have a bit of a soft spot for America. Do they bring their national or their nationality to bear in these things?
Sometimes. So you might expect the claimant side appointee to favor the claimant and the respondent state appointee to favor the state. They are supposed to feed into the process that produces this ruling. And again, the presiding chair is the third member of this tribunal, will usually determine outcomes. So certainly they channel those sentiments. They might not rule in favor of their appointing side. That often will happen.
That often happens. How about if a decision comes down, and since they all go against us, let me pick it this way, Canada doesn't like the decision. Is there room for appeal?
No, not really.
So that's it.
It's typically it. There are some grounds of review that are available under something called the International Center for the Settlement of Investment Disputes, called ICSID, which is housed at the World Bank.
What a horrible acronym.
It truly is. and there's a review mechanism there. In addition, if it's not under the auspices of this institution at the World Bank, national courts can review on very limited grounds these awards depending on the seat of the tribunal. So these tribunal hearings can take place in any number of cities. And so Canadian courts have on occasion reviewed these NAFTA awards, but on very limited grounds, typically not on the merits, typically on a very narrow set of procedural issues.
And one last question on this part. What if a ruling goes against a particular company in Canada and the company just says, A, I can't afford to pay, or B, I'm not going to pay? What then?
Well, the tribunal will be determining a case brought by a company against a state. So the company might lose the case. Typically, there isn't an award of damages against a company. They may be required to pay costs, and they might not want to do that. They might go bankrupt. It's interesting that some of these claims are being sold to third parties. So there are investors in this investment dispute settlement mechanism who are purchasing these claims from companies that have invested. And so they divest themselves of this claim entirely, and these third-party funders, investment bankers, and others take over the claim. They might choose to not pay up either if they're required to.
Let's go back to the example you gave at the beginning, where this American interest wanted to build wind farms in Ontario. The government of Ontario decided, thanks, we got enough green electricity generation here. We don't need these after all. We're breaking the contracts. The American investors got upset. They won. Does the government of Ontario, meaning the citizens of Ontario, are we now obligated to pay a damage to these American interests?
The citizens of Canada, including the citizens of Ontario. So it's the government of Canada that's on the hook. In international treaties, the government of Canada signs them and commits to them, and they are the respondent states. So Ontarians themselves are not solely on the hook. All Canadian citizens are on the hook for the payment of damages.
I can just imagine how thrilled other provinces are to be on the hook for decisions made by... Anyway, moving along. How is the government of Canada dealing with this conundrum they now find themselves in?
Well, they've adopted a proposal made by the European Union. The European Union was in negotiations with the United States for a new trade and investment agreement. The acronym there is TTIP, not a great one either. And negotiations were put on hold because of opposition to this investment chapter part of TTIP. They put negotiations on hold, undertook a European-wide consultation, and came up with a response, which was something called an investment court, which isn't really a court. It doesn't have independent and impartial judges. It has, again, these arbitrator lawyers who resolve these disputes. They are on a roster, so they're not chosen at large ad hoc, but they're on a list. And there's some limits on what these arbitrators can do. So there's a lot of movement in the field between people sitting as arbitrators, people litigating these cases, writing about it as scholars. There's a revolving door in there, and the investment court proposal is intended to limit some of the conflicts of interest that arise. but it looks pretty much like the system that we have. That's the proposal that the Europeans put on the table with the Americans who weren't interested, which is very interesting. But the Liberal government, when it came into power, almost immediately adopted this into CETA, the Canadian-European Trade and Investment Agreement. So that's the one adjustment, it seems to me, significant adjustment that the Canadian government has undertaken. There's some attempt to narrow the standards of protection for investors in CETA, but they're still very broad, and they still render vulnerable all types of policy changes.
But here's the thing. If you were advising the government of Canada right now on what to do about all of this, you've got Donald Trump campaigning, saying that NAFTA is the worst thing ever and he's going to rip it up. And then he has a meeting with Justin Trudeau and he says, actually, it's not so bad. We're going to tweak it a little bit. And then somebody else got to him and he says, actually, no, I was right the first time. It's terrible. We got to rip it up. And then Justin Trudeau calls him again and he says, well, maybe we don't have to rip it up after all. And now he's out there again saying it's a disaster and we're going to have to rip it up. I mean, what advice do you give to the government of Canada in a situation like that on how to handle this?
Well, in regard to trade matters, it's pretty complicated given the integration of Canadian and American and Mexican markets. In regard to investment dispute settlement, again, it doesn't seem to be much on the Trump radar. I don't think he has a deep understanding of it. His Secretary of State, Rex Tillerson, might have a better understanding of it, and
Wilbur Ross, too.
And Wilbur Ross, and
Commerce Secretary.
USTR, the U.S. Trade Representative, Robert Lighthizer.
Yes.
Who's coming on board will have a better understanding. I think Canada could safely abandon ISDS, and it would cause no disruption, it seems to me, to trade flows nor to investment flows. And I think we should rethink our model. I think we have an obligation to rethink our model, not only in regard to the capacity of the Canadian government and provincial governments to make policy, but also the imposition of constraints on developing countries. I think we have an obligation to think globally about the kinds of constraints we're putting upon countries that need some room to maneuver, particularly as they respond to some of the difficulties that all countries are responding to in light of economic globalization.
Sadly, I have no more room to maneuver because that's our time. David Schneiderman, law professor, University of Toronto. It's good of you to come into TVO tonight and help us out with this.
My pleasure.
Help TVO create a better world through the power of learning. Visit TVO.org and make a tax-deductible donation today.